Hi, this is Frank Walker of Frank Walker Law, and I want to talk to you briefly about premises liability. So what exactly is premises liability? It's a term we like to use as attorneys that talk about what are the duties of a landowner when they have visitors to their property. A landowner has a duty of care to protect against any unsafe conditions on their property. What does that mean? You got potholes. You have dents, you have rocks or glass, you have hanging icicles, you have ice on the sidewalk. There are cracks in the sidewalk. There are cracks in the yard. There are different types of dangerous conditions on their yard that are known or should have been known by reasonable inspection of the yard. Now, let's say you're having a cookout and someone comes over and they slip and fall or they trip and fall based on a pothole in your yard, or they trip and fall on the sidewalk or slip and fall on the sidewalk. You, as the person who are invited to their place, they owed you a duty of care to make sure they have warned you against any dangerous conditions and they have protected against any dangerous conditions. If you are injured on someone else's property, the first thing you need to do is seek medical attention. What type of medical attention do you need? Do you need to go to the ER? Did you need to go to the ER in an ambulance? Is someone going to be able to drive you or take you? There are certain types of care you may need immediately and also some follow-up care. After your initial care and your follow-up care, make sure you complete the follow-up care. Every one of us, they want to rush back to work. Oh, I need to go back to work. I need to do this. I need to do that. No, you need to get better, because if you rush back too quick, you may re-injure yourself, or you rush back too quick and you're not ready to go back to work. That may have an impact on your employment. So if you have to take care of yourself first. Then you contact an attorney to seek compensation for your damages. What type of compensation could that be? It could be monetary. It could be financial. And there are other types of compensation a personal injury attorney can talk to you about, but you have to speak to them immediately because there are certain guidelines and timelines you have to abide by. Typically in Pennsylvania, the statute of limitations is 2 years from the time you knew or should have known that you were injured on someone else's property or by the negligence of someone else. So to recap, you get injured on someone else's property because there was an unsafe condition. It was due to their negligence. They didn't protect you. They didn't warn you about the unsafe condition. It was a known or something that should have been known or discovered based on a reasonable inspection of their property prior to inviting you over to their property for whatever reason. You get injured on their property. First step, what do? You know the answer. You seek medical attention. After you seek medical attention, you follow up. Don't stop, because if you stop, then the person's going to look at you later on and say, wait a minute, all you did was go to the ER. You weren't really hurt. You didn't do any follow-up treatment. So your case is valued at this amount versus what it could have been valued at if you would have continued on with your treatment. But that's a conversation you'll need to have with your personal injury attorney, which is step 2. Step 2 comes after step 1. You're not calling the attorney immediately before you go to the hospital. Go to the hospital first. Get your treatment. Get better. Figure out what you need to do to get yourself in the condition you would have been in but for that injury. Then you contact an attorney, tell them about your injuries, tell them about what happened. Do that in a timely fashion, because there are guidelines and restrictions that may prohibit you from bringing a claim after a period of time. In Pennsylvania, for personal injury claims, in most cases, it is a 2-year statute of limitations, meaning after those 2 years, you could be barred from bringing any type of action against that person, the injuries you sustain as a result of their negligence. Again, step 1, medical treatment. Step 2, reach out to an attorney, because step 3, there is a timeline by which you can bring your claim. Again, thanks for listening to me rant about personal injury claims and what you have to do for premises liability. But in all seriousness and all candor, I need you to understand there are certain steps you have to abide by, because if not, you may be barred from bringing that claim. Any questions, feel free to reach out to me via the information below, and thanks for listening.